Exhibit 802 crystallizes the deadly decision.
So it looks to me that that's the moment right there when she understands that it is going to be a murder conviction. Intentional car crashes are not something you hear of very often, and usually most of us do our best to avoid a car crash. I know I do. I'm sure many of you have seen clips about this case right here floating around the internet, and today, me, America's attorney, is gonna react to and break down the court's announcement of a guilty verdict. In this case, let's just jump right into it.
Before I render the verdict in the case, I want to thank the attorneys for your professionalism and your advocacy in the case. I know it was a difficult case for everyone, including the attorneys and your staff.
I hate to pause it right here because I can feel the tension knowing that the court is about to announce a verdict, but I just want to say that after a trial, judges almost always compliment the attorneys on both sides. It doesn't mean that they did a great job, and it doesn't mean that it was like a close case. It's one of the things that judges do just to be polite, and I think also to help the attorney on the losing side not have to get like verbally abused by his or her client after they lose. So let's see what happens here.
For the families of those involved, I recognize that this trial has been a very stressful event for you.
Wow.
And that stress follows you even when court has ended session. I appreciate that despite that stress, you all worked with me to ensure a safe and respectful environment for everyone here. In a bench trial, the judge sits as the jury and the finder of fact, as well as the ruler of law. And it is a reminder of just how difficult a job it is to serve as a finder of fact. I have done what I am sworn to do. I have carefully and deliberately considered all the evidence in this case, including the testimony of the witnesses, the science, the expert opinions offered, the medical evidence, the physical evidence, the photographs, and the video evidence. This trial is a culmination of decisions made by one person, the defendant. Those decisions have forever altered the futures of 3 families.
I got to interrupt right here and say a couple of things. When she says that the events of the day were a result of decisions, a decision is like where you make up your mind to do a certain thing. That should be telling everyone in the courtroom, literally every single person, you're about to see a murder conviction. Because if it's going to be manslaughter or any sort of reckless or negligent homicide where there's not intent, a judge would never talk about decisions that are being made. So she's forecasting the outcome right here.
Of you also, Mackenzie. And your decisions forever robbed Dominic and
decisions again.
The futures that they had before them. If there is one thing that can be taken away from this case, as painful as it is this. Every decision we make is important. Every action we make is important.
Continuing to talk about decisions.
Regardless of whether the decision is a good one or a bad one, or the actions are good or not, the result is the same. The consequences ripple through time and affect many more people than one might think at the time of the decision. In criminal cases, the state carries the greatest burden under our law, proof beyond a reasonable doubt. As I previously stated, I considered all the evidence presented. And at this point, I would like to comment specifically on Exhibit 802, the crash video.
Yeah, I mean, if you know anything about this case, when the judge says she's considered all of the evidence, like the medical records, testimony of law enforcement, testimony of first responders, et cetera, honestly, all of that pales in comparison to the video evidence. And we'll play a clip of it so you can see. It's just, the video is the entire trial.
This is the type of evidence you can never unsee. You can never forget the visual or audio of this exhibit. It is chilling and tragic. As you review that exhibit, you know that you are watching the oncoming deaths of 2 people, and there is nothing that will stop it. The video clearly shows the purpose and intent of the defendant. She chose a course of death and destruction that day. Exhibit 802 crystallizes the deadly decision.
So it looks to me that that's the moment right there when she understands that it is going to be a murder conviction. If you don't know, when the judge is saying decision, and over and over, and you don't know that that is like legal code for intent, then you might not understand it. But at this point, she says basically like you chose to kill them. So that's where it looks like this young lady has figured it out.
Making of the defendant. She morphs from a responsible driver to literal hell on wheels as she makes her way down the street. Mackenzie alone made the decision to drive the car, to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her. Mackenzie alone chose the time to make the drive, early in the morning, when any reasonable person would expect that few people would be nearby to witness it or offer life-saving assistance.
Okay, so a couple of points right there. She's saying that during the trial, the prosecutor put on evidence that Mackenzie had functionally scouted this route so that she could see that she had a runway to drive very fast into a building. And of course, those don't exist everywhere. And so that's relevant. And then also the time of day is relevant. The judge is saying it's 5:30 in the morning. You knew that you were going to be able to get down that road without anybody in front of you and be able to reach those deadly speeds.
She made these decisions despite knowing, as any reasonable person would, that her mission of death could have involved others, not even in the car with her. Other people, other cars, pedestrians. She had a mission, and she executed it with precision. The mission was death. Mackenzie alone decided to push the pedal to the floor and demand the ultimate speed of that vehicle to 90 to 100 miles per hour. She alone decided what was to be. Mackenzie decided death was the ultimate goal that day, and she alone made that decision for Dominic and Devion, and she continuously acted in a manner to achieve her purpose. Whether or not she intended to also kill herself is a matter of speculation. They have no relevance to the weighing of the evidence in this case. The totality of the evidence clearly demonstrates that Mackenzie Shirilla acted purposely and intentionally in the early morning hours of July 31st, 2022, and her purpose was to kill Dominic Russo and Devion Flanagan. No reasonable fact finder could view the totality of this evidence in this case and come to any other conclusion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. This was not reckless driving. This was murder.
I'm thinking right now about the Henry Ruggs trial. You know, he recently pled guilty to a felony DUI and to a misdemeanor negligent homicide. If you remember, this was the Denver Bronco wide receiver who was driving his Corvette supposedly 156 miles an hour while twice the legal limit of blood alcohol in his body. These two cases are very different in that what Ruggs did was stupid, right? And he got 3 to 10 years of a sentence. We don't know exactly how much he'll do. But what the court is declaring here is not that this was stupid, but that it was wicked, that it was a plan. She pointed out, she probably used the word decision 10 times. She talked about purpose, talked about choices and choosing, very much making it clear that this is the sort of intentional death that the murder statute is exactly designed to describe.
Court renders the following verdicts. Count 1. The court, having had count 1 tried to pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.
Oh, whoa, that's quick. Oh, my word. Did you see what just happened? There's a whole bunch of charges against her, right? The court announced guilty on the first murder charge. It looked like it was like 2 or 3 seconds, and the deputies are coming in to handcuff her. They're not even waiting until the rest of the results are announced. That is wild. I mean, it makes sense in that as soon as that announcement is made, then it's clear she's going to prison. I've just never seen officers swoop in to cuff a defendant at the moment of conviction. They just normally wait until all of the counts are read out. Wow.
2.02A is charged in count 1.
Wow, that was
Count
fast.
2. The court, having had count 2 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of murder, to wit, Davion Flanagan, in violation of Ohio Revised Code section 2903.02A is charged in count 2 of the indictment. Count 3, murder. The court, having had count 3 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of murder, to wit, Dominic Russo, in violation of Ohio Revised Code section 2903.02B as charged in count 3.
I'm going to interrupt real quick and I'll be very brief, but she keeps saying having it tried to the bench pursuant to a waiver. Mackenzie Shirilla, through her attorneys, they both signed off on a form, apparently, that says no jury trial. That's not very common in a murder case, and I'm sure that there was some strategy behind it, but that's why every time the judge announces a new verdict, she says pursuant to a waiver, because you have to waive your right in a criminal proceeding that's a felony in writing with your signature. You have to waive your right to a jury trial because you have one guaranteed to you under the 7th Amendment. So she keeps saying pursuant to a waiver, pursuant to a waiver.
Count 4, murder. The court, having had count 4 tried to it pursuant to a waiver, finds the defendant Mackenzie Shirilla guilty of murder, to wit, Dominic Russo, in violation of Ohio Revised Code section 2903.02B is charged in count 4. Count 5, felonious assault. The court, having had count 5 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of felonious assault, to wit, Dominic Russo, in violation of Ohio Revised Code section 2903.11 of the Revised Code is charged in count 5 of the indictment. Count 6, felonious assault.
Real quick, an assault is a battery before it happens. So if you see that you are about to run into a brick wall, which is what they did, and you're aware of it, then you are the victim of an assault. A lot of people think that an assault is a touching, an unwanted touching, an injury. That's actually a battery. So the reason that she can be guilty of both murder and assault is that she didn't sneak up behind them and kill them. She had them in the car headed towards the building. And so the law criminalizes the act of putting a victim in anticipation of the unwanted touching or the felonious injury like that.
The court, having had count 6 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of felonious assault, to wit, Dominic Russo, in violation of Ohio Revised Code section 2903.1182 is charged in count 6. Count 7, felonious assault. The court, having had count 7 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of felonious assault, to wit, Davion Flanagan, in violation of Ohio Revised Code section 2903.1181 as charged in count 7. Count 8, felonious assault. The court, having had count 8 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of felonious assault, to wit, Davion Flanagan, in violation of Ohio Revised Code section 2903.1182 as charged in count 8. Count 9, aggravated vehicular homicide. The court, having had count 9 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of aggravated vehicular homicide, to wit, Dominic Russo, in violation of Ohio Revised Code section 2903.0682A is charged in count 9. Count 10, aggravated vehicular homicide. The court, having had count 10 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of aggravated vehicular homicide, to wit, Davion Flanagan, in violation of Ohio Revised Code section 2903.0682A is charged in count 10. Count 11, drug possession. The court, having had count 11 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of drug possession in violation of Ohio Revised Code section 2925.11A as charged in count 11. Count 12, possessing criminal tools. The court, having had count 12 tried to it pursuant to waiver, finds the defendant Mackenzie Shirilla guilty of possessing criminal tools in violation of Ohio Revised Code section 2923.24A is charged in count 12. Sentencing will be 1 week from today, August 21st at 1 p.m. If any party wishes to file a sentencing memorandum, it is to be filed by 4 p.m. on Thursday, August 17th. Thank you.
Thank you.
And then they're just going to lead her away because she doesn't get the opportunity to hug her parents or say goodbye or anything like that. She is now in the custody of the state of Ohio. I think one of the reasons that this conviction is so odd and feels so surreal is that if you think about what was actually going on here, this was supposed to be a murder-suicide, right? One of the victims was her boyfriend. They had an on-again, off-again tumultuous relationship. What makes it odd, there are two things. Number one is that there was a third person involved. She had her boyfriend's friend in the car with him. And I think one of the reasons that the court is viewing this as so incredibly callous is that it would have been possible for her to just dump this guy out of the car, like to get him out, to do this at a time when his friend wasn't in the car with the two of them. So this collateral damage, it makes it not some sort of like crime of passion, like a regular, I mean, if there's such a thing as a regular murder-suicide between lovers. And then the other thing, and this is the thing that really is kind of mind-blowing, is that she didn't die. I mean, you saw that brace on her arm, but she survived. Murder-suicide is still murder. And if the suicide victim was unsuccessful in killing herself or himself, they would be put on trial for murder just like she was, irrespective of the fact that they intended to take their own lives. And she didn't walk away, but she came away from this alive, but she's still a double murderer, even though she did not succeed in the suicide part of her plan. So although the verdict came out, the court is announcing sentencing in a separate proceeding. If you have not seen that proceeding, don't cheat. Tell me what you think down below in the comments. Give me your pro se opinion. If you were on the jury, which there wasn't one, or if you were the judge, which you're not, how long would you sentence her for a double murder and a failed suicide attempt? And while you're down there, hit the subscribe button. It's a personal goal of mine to hit 50,000 subscribers this year. I would love for you to be a part of it. If you like this video, check out these other videos. I'll be back soon. Thanks a lot. Bye.